Hello everyone, Kousha Adhami from Adhami Law Group. Today I'm going to talk about marriage green card cases and the step and the process that's required for each individual to be able to apply for their green card. I invite you to watch this video in its entirety and stay safe. Welcome everyone. So today I'm going to talk about marriage green card cases and the process that's required for each individual to be able to apply for their green card. Before we go forward, I would like to put everyone on notice that they should not engage in any sort of fraud marriages, because fraud marriages can have severe consequences both for the undocumented individual and the United States petitioner, okay? Be very careful regarding this process. Now, with that being said, let's move forward. Before I go in detail to talk about this process, there are certain terminologies that I would like to address so that our viewers and listeners can understand this process better, okay? So, when I refer to, for example, USC, I'm referring to United States Citizen Petitioner or United States Citizen. LPR is equivalent to green card holder or legal permanent resident. USCIS is United States Immigration and Services. Petitioner is usually referred to the United States Citizen Petitioner. Beneficiary or applicant is referred to the undocumented individual that's being petitioned by United States Petitioner. EOIR is referred to as immigration courts. Consular processing is a process where the individual applies for their green card outside the U.S. Adjustment of status, or AOS, is referred to for individuals that are applying for their green card in the U.S. Removal proceedings is referred to as the process where the individual is placed in immigration court proceedings. IJ is immigration judge, and removal order is a deportation order or an order that's been issued by an immigration judge. Okay? All right. So let's move forward. There are three ways for an individual to obtain their green card through marriage. So pretty much there are three different entities that are able to grant an individual a green card. First one is USCIS, also known as United States Citizen and Immigration Services. Second is the consulate. And third is the immigration judge. Now, let's move forward to the next step. The first thing that an individual must consider in applying for their green card, and the first thing that immigration looks at, is their manner of entry. If they enter the United States legally, then there's a very high percent of chance that they can apply for their green card in the United States. If they enter the United States illegally, that means they were not inspected or admitted or paroled, then they would probably have to apply for their green card at a consulate. That means they will not be eligible to apply for their green card in the U.S. Now, let's go a little bit more in detail. Okay, now, for individuals that enter the United States legally, that means they were inspected, admitted, or paroled. That means they have legal admission. And when they marry a United States citizen, they can apply for this process called the adjustment of the status. Okay? This process also laid out under INA Code 245A, okay? Another way is if the individual entered the United States illegally, that means they were not admitted, paroled, or inspected. So when they marry a United States citizen, they would have to, more than likely, apply for their green card at a consulate, not in the United States. There is a slight exception under this process, and that process is called 245I. And in that process, the beneficiary is able to apply for their green card in the United States, but only if they were petitioned by a family or employer, and that petition was dated April 30th, 2001, or prior to that. So the date is the beneficiary was petitioned by an employer or an employee before April 30th, 2001. And that would also allow that individual or the beneficiary to apply for their green card in the United States. Okay, now, whether you enter the United States legally or illegally, or you're eligible for 245I, you must still have to go through the first step in the process. And that process takes place before USCIS. Okay, now, what is that process? When the applicant or beneficiary marries a United States citizen, they need to file a petition before USCIS. That process is called I-130 petition. That's the most important process, okay? And in that process, they both must show and prove to USCIS that their marriage is bona fide. What does bona fide marriage means? Bona fide marriage, the literal definition from INA and Immigration Court and USCIS states here that the bona fide marriage is a genuine marriage entered into good faith with the intent to establish a life together rather than obtaining immigration benefits. That means you should not be filing this petition with USCIS if you just want to get your wife or husband a green card. You must prove, and the intent of the petition is show that, yes, you are married, but the sideline, this person is also petitioning this individual to apply their green card. Now, one of the things that my clients ask me, they're like, okay, Kousha, so like, what do we need to do? What are the documents required? Of course, it varies based on each individual because we look at the length of marriage, the documents you have, whether you are married before, divorce, and all that. But if you can prove to me with your documentation that your marriage is bona fide, I have no problem proving to the judge or an immigration officer that your marriage is bona fide and real. And once you have that burden proved, you're going to be able to get your I-130 approved. What is the next step after you file your I-130 petition? There's a very high chance that immigration will schedule an interview, okay? And the one word I can describe your interview and how you should deal with it is one thing: preparation, preparation, preparation. The more you're prepared for your interview, the better you're able to get your I-130 petition approved and have less chances of being your case deferred to a secondary officer for review, or where the USCIS will issue a request for evidence, okay? So preparation is very, very important. I will prepare another video where I'm going to go in detail to talk about what to-dos and what not to do for your I-130 petition and for your interview, okay? For more information, please visit our website at adhamilawgroup.com or call our office at 213-204-6500. Stay safe.